I thought I would start by introducing myself and John. I'm a reporter with the Wall Street Journal here in Brussels, and I cover antitrust, tech, and telecoms regulation. And I'm also very, very proud to present John today. John Frank is the Vice President of European Government Affairs at Microsoft, and he's been in Brussels since last November. Before that, he was the Deputy General Counsel working on law enforcement, national security, and competition policy issues. And John, you've had such a, you've had such a long, distinguished career at Microsoft, and I'm curious before we jump in to hear more about, why Microsoft decided to bolster up its Brussels office by, with your presence.
Our industry is going through a great transformation with the shift to cloud computing. And cloud computing changes our relationship with our customers and the opportunities for what our customers can do. And so we're, for the first time, not just providing technology that they use on their premises, but we're holding their data. And we're also bringing intelligence with artificial intelligence and machine learning capabilities to our customers to help them transform their businesses to remain and become ever more competitive. And so the shift is profound. Brussels is the center of regulation for the IT industry. Washington, D.C. talks about it, but Washington, D.C. doesn't really do much. Brussels acts. You may not always agree with what they do, but this is the center of regulation for our industry. And so, given the transformation, there's new issues to be discussed, and this is the place to discuss them.
So Microsoft in July won a major legal battle against the US Justice Department with an appeal court ruling that the government cannot force the company to turn over emails and personal data on computers overseas to the law enforcement. But at a time when the terror threat is rising both in the US and Europe, I'm curious to hear your opinion. What's more important, ensuring that customers have 100% guaranteed privacy, or potentially helping thwart a terror attack?
Well, I was on point for Microsoft during the Snowden disclosures, and I think we learned a lot from that, including we learned a lot of things about what the government was doing that we didn't know. But one thing that became clear was that we all need to operate within a legal framework that's transparent. And so we did set out to say we're willing to challenge laws that the government asserts, but the text doesn't support. And so the Stored Communications Act, we believe, does not support a warrant for data stored in our European data centers. And so we initiated that case because the statute didn't support it. Now, governments do need access to data, but they need to do it through a legal framework that democratic institutions agree upon, and do it in a way that we can be transparent with our customers and that customers can feel better about. Now, in this particular case, we came to the conclusion that Europeans feel much more comfortable having their data protected by European privacy law and not by a judge in the United States. And so we thought this was an especially important case. We've seen more and more of our data for European customers now resides in Europe. We're building data centers around Europe as fast as we can. The opportunity for Europe is to figure out how it wants to be able to manage data stored in Europe. Because currently, there really isn't a very good system, and there's no agreed upon rules for the access of stored data. And I think there's an opportunity to advance that because public safety and security is a very important priority, but especially governments and organizations, they want to know when a government's going to access their data and that there's appropriate protections in place.
Well, as a follow-on to that, and a lot of EU officials after the Paris and Brussels attacks, they had complained that many American internet companies hadn't done enough, for example, by allowing access to communications between suspected terrorists. And they even went as far as saying this, is creating a real hurdle to the investigations into the Brussels attacks. And so I'm wondering, how do you think Microsoft has fared? Do you believe that you have cooperated well with law enforcement?
Because I used to manage the team that responds to requests from governments, I stayed in close touch after the Brussels attacks and reviewed the requests that came in. And in fact, we did respond very quickly. I mean, after the Paris attacks, I think we responded within 45 minutes of receiving the emergency order. But there's a clear legal framework for us to do that. And so under the US statute, when there's requests that we, the service provider, have a well-founded belief that it's appropriate to save human life or prevent serious bodily injury, we can disclose customer content. These are all individual Hotmail accounts. And after the Brussels attacks, there were a number of requests, and we responded those, and we went the extra mile to try to suggest how they could frame their requests to be as productive as possible. So we can do that. The problem is we don't have a clear legal framework in Europe for data stored in Europe for such emergency requests. We have a decision in Ireland from the Data Protection Authority that gives us some comfort. We have some legal opinions. But in those cases, the request went from the Belgian government to Washington, D.C., to Redmond, Washington, to Dublin, back to D.C., back to Belgium. And the European capitals need a way to be able to manage these issues in the same time zone, because more and more customer data of Europeans about what's happening in Europe is stored here in Europe.
So the European Commission is expected to update its telecoms rules in September, and one possibility would be to include new rules around privacy and security for apps and internet services as a way to balance with the telecoms operators who have to at times comply with requests for wiretaps. And being the owner of Skype, what is Microsoft's position on this?
If governments want to establish rules through democratic processes about the trade-offs of privacy and security, that's fine. One does have to recognize the underlying technologies. And the telecoms rules, perhaps they should be adjusted for telcos, but for most of us, we don't have infrastructure in every country. The nature of a telco is there's a public network with infrastructure there. With Skype, there is no infrastructure in most European countries, and so there's no, you need to work through the jurisdictional basis of who can access what, let alone, and leave it to us to, there's the whole technology challenges, but so it's not a terrible idea to think about, are there ways where governments want to regulate this? But one has to recognize that you can't use a regulatory model for completely different technology with a different infrastructure.
And so switching over to the Privacy Shield, with which James gave a good account of, Microsoft was one of the first companies to sign up to this new mechanism, which replaces the previous safe harbor, as James had mentioned, that was overturned by the European Court of Justice, largely on concerns of mass surveillance by US authorities. I'm curious to hear why Microsoft is so confident that this won't be overturned by the courts as well.
The Privacy Shield was a very tough negotiation between the US and the European Commission. And in part because I think for the first time they actually had to dig much deeper. The court decision challenged them on a number of levels about what they hadn't gotten right the first time. And so I think they both had to look much deeper in understanding how US law really works and how European law really works. And so we were involved in discussions with both Commerce and the Commission on different sticking points. And there's a number of judgment calls that were made, which, some of which we might not agree with, but overall, they spent a lot of time building I'd say a solid foundation. Plus, I think when they went back to look, they hadn't really kept the old mechanism up to date. And so this new mechanism includes an annual review, and I think there's members of the European Parliament who are strongly encouraging reviews of particular issues on a regular basis. And that's good, because we need to make sure that as the services evolve, as usage evolves, that we continue to look at these things. And so I think that this agreement has a much deeper foundation, much better integrated with how the world really works, and it's not going to be evergreen forever, but there's a mechanism in place to ensure that it gets looked at and gets reviewed and gets updated.
Just a quick follow-up on that, but because there's this review mechanism and that it gets updated often, is it still going to provide as much certainty for companies transferring data as the previous mechanism did?
In a sense, I think it provides a great vehicle for companies. And it's not just companies, it's universities that participate in online courses across the Atlantic. And there's a number of people who need to manage data, not just in the way of some internet companies, but just for everyday operations of businesses. And it does provide a much more detailed foundation of what you need to do. And there's also there's an incentive to sign up by September 30th, I believe, so you get the 9-month transition period for your subcontractors. And so I think, not surprising, privacy lawyers took vacation this summer as well. And so I think we're going to see more and more companies this month paying attention to the Privacy Shield and taking steps to sign up.
So in light of the big news in Brussels against Apple last week, and as another fellow US tech company with a significant presence in Ireland, which is obviously known for its low corporate tax rate, is there concern in Microsoft about how the EU treats US companies operating here, especially with regards to their tax arrangements?
I can't comment on the Apple case. I don't know enough about it, and wouldn't want to discuss their situation. But more broadly, I think a lot of us agree that there's room for improvement in how tax laws are applied to multinational corporations. It's incredibly complex when you're operating in 120 countries and you've got accounting rules that are complicated, and yet there's room for improvement, but don't expect corporations to solve the problem. This is something governments have to do, and governments have to discuss and cooperate. But we're participating in the OECD process because we think that it's a way to get from our current state to a better place, that our tax bills may go up, but it's a sustainable framework that I think is going to, pursuing the avenue through multilateral discussions is eventually the solution.
So it looks like I have time for one last question, and because I have you here, this is a bit off topic, but I'm very curious to ask you, what is behind the peacemaking with Google on, this agreement that both companies decided not to file antitrust complaints around the world against the other company? And why did you decide to come to this agreement now at a time when the Commission is really moving ahead with some of the antitrust complaints against Google?
Well, actually, I think our agreement is to talk to each other first.
Okay.
Which, no, I mean, for a lot of years, the nature of a rivalry in an industry is that you can convince yourself that you're right and the other person's wrong, but as a practical matter, there's just lots and lots of areas where we just needed engineers to work out issues of, how does our browser work with their search, and how does their operating system treat some of our apps, and so we decided that we would apply European principles, but we would have discussions first. So we haven't said nobody will ever file a complaint. We have said that we will talk to each other first. And why now? Because Satya Nadella is our CEO, and he decided that it was more important to have a cooperative relationship with Google and to work with them rather than bring regulatory actions. And so we do have a much better discussion. It was actually post-Snowden in those sets of disclosures that we began working together for the first time. And not without hiccups, but we both filed lawsuits against this Department of Justice seeking the ability to publish transparency reporting on the FISA orders that we received. And we both filed them within a day of each other in the same district court in Washington, D.C., and we both settled those cases together. And that was really the beginning of where, on regulatory issues, that we began cooperating. And I have to say, it's much nicer to have relationships in the industry where we can disagree, but we can at least have a good dialogue.
John, thank you so much for your candid and interesting answers, and yeah.